Madam Chair, members of the committee, Ben Lopez with Traditional Values Coalition. I'll echo some of the thoughts of my colleague from PGI. This bill, obviously we're opposed. This bill is based on the provisions in Penal Code Section 422.56, which states, and I'm quoting the law currently, gender means sex and includes a person's gender identity and gender expression. Gender expression means a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. What we have a problem with is, and we understand this is currently law, but this bill would take it a step further and apply it to privacy situations where women and men or males and females would share basically very private quarters. This bill takes an open-ended definition that leaves it open to the individual to define what gender is. And there are no, neither this bill nor current law affords a clear definition as to what constitutes legitimate gender identity or gender expression. This bill, we feel, opens up Pandora's box and creates a slippery slope by allowing anyone to claim that they are something sexually and then have full access to the opposite sex facilities without regard to privacy. This is an offensive policy that would not bode well with the majority of students and parents. There's a general consensus among those of us in opposition that there is a complete disregard for the privacy of the vast majority of students who are not transgendered or gender questioning. These students and their parents have a reasonable expectation that they will not be forced to share intimate spaces with members of the opposite biological and anatomical gender. There are no safeguards whatsoever in the legislation that would allow responsible adults, as my colleagues have said, including coaches, teachers, chaperones, school administrators, and others, to act in the best interest of all students. We would contend, though, that the real victims here are not necessarily those who are gender questioning, but also those who may object, rightfully so, to sharing private situations with others that they may not be comfortable with. Now, there are, I know the analysis is sharing court cases that state that California's anti-discrimination laws were not have been unsuccessfully challenged. However, there's precedent in other states, and even some liberal states as Minnesota, and including even the Ninth Circuit Court of Appeals, have ruled that privacy is paramount to anti-discrimination laws. That was the Ninth Circuit, the ruling that they made with regard to the Fair Housing Council case in 2012. By opening all such facilities to any person who simply perceives, dresses, and acts like a different gender or sex than they were born, and can ultimately change such perceived gender at any moment or at a whim, AB 1266 ensures no level of privacy be maintained regardless of the wishes of those who would object. The real victims of this bill, again, would be forced and subjected to giving up their privacy for the unjustified accommodations of transgendered individuals. There's a degree of expected privacy that must be provided both publicly and privately. Just think about the needs of women that they must, majority of women must share in the bathroom. I don't think they want to give that privacy up. There also, you could, based on this bill, if there could theoretically be a women's softball team that has a majority of biological males on it, this bill is very open-ended, no clear concrete definitions, either in the current law or the bill. There is no basis. I think only CIF has a concrete policy to set in place what is justified gender expression concerning sports and teams, but the current law does not. For that, we would respectfully ask, a no vote on the bill.